Good afternoon, everyone. Thank you so much for joining us today with the American IV Association and our monthly webinar. We are here with three wonderful and very knowledgeable individuals that come from Gordon Reese, Scully, and Mansukhani. Each person has, the firm has been around for over 40 years, and it now covers at least, has representation in all 50 states. We have with us, they'll be covering why legal guidance is imperative before opening an IV hydration therapy business. With us today is Miss Allyson Avila, and she practices mostly within New York and outside of the many other areas that she covers, but she also focuses in on the healthcare and healthcare regulatory and transactional policies and law. We have Justin Puleo. Mr. Puleo practices outside of North Carolina, or outside within North Carolina, and is within business transactions, healthcare, regulatory, and life sciences. And then we have Mr. Jason Kalkirtz, practices in Virginia and has extensive knowledge navigating the regulatory landscape of state and federal agencies, such as the FDA and USDA. And we welcome you all, and we will have a Q&A. So if you have any questions as you're listening to these individuals speak, go ahead and type them in and I'll be sure to share them. And they're going to go ahead and start covering why it's important to start with the legal side of business. Take it away.
Good afternoon, everyone. So we've been asked to discuss why it's imperative to have counsel before you start an IV hydration business. And a little bit about myself. I represent a lot of medical spas, physicians, nurses, other healthcare providers, and do a lot of transactional work. And one of the reasons why we've been so busy here is because a lot of people are opening up practices and IV locations without really doing the proper homework, and then they get cited by various governmental agencies for failing to comply with regulations. So I have Jason and Justin here with me. They're amazing, and they do a lot of the healthcare regulatory work as well with me. So we thought that it would be great for the three of us to be able to, take your questions. Unfortunately, a lot of the information is very state specific. So if you have state specific questions, we might not be able to answer them with clarity, but are more than willing to answer questions, after this webinar. But I'll let Jason and Justin introduce themselves to you, and then we can get going.
My name is Jason Kalkirtz. I'm senior counsel here at Gordon Reese. And I primarily help clients regulate FDA regulations, anything FDA regulated, from food, supplements, cosmetics, drugs, devices. That's kind of my expertise, and help clients navigate those regulations and stay compliant.
Justin here, and I have the pleasure of working with Allyson and Jason, two experts in the field. And this is a multidisciplinary field. A lot of areas of law come into focus when you're dealing with medical spas and IV hydration therapy. I primarily focus my practice on joint venture design, building compliant relationships between providers, management companies, supporting providers, even private equity trying to get involved in healthcare. I make sure nobody steps in any of the landmines that are numerous. Even in the cash pay business, there are several things to consider. Professional fee splitting being one of them. So I help clients keep from running afoul of things like Stark, the anti-kickback statute, corporate practice medicine, fee splitting, ECRA when it comes to labs, and then of course medical board and pharmacy board and nursing board rules. So that's kind of my angle of approach here. And again, very, very fortunate to have Allyson and Jason to work with, and we all bounce ideas off of each other, because a lot of these questions are very unique. to the client, very bespoke, very state specific. Every client, wants, has a very special need and business plan that they want to implement. So we're able to bring to bear our, various angles of expertise. And then also, if it hasn't already been said, Gordon Reese, it's the only law firm that has offices and licensed attorneys in all 50 states. So we as a team can help get you a compliant business plan, and we can also liaise directly with boots on the ground attorneys in your state if anything is needed face to face in person with the nursing board, for example, or something like that, or if there's some site inspection. So a privilege and an honor to participate, and thank you for having me.
Thank you, Justin. I wanted to just touch on a couple of things that you said, Justin, which is very important. One of the things that I work with Justin and Jason a lot is the management agreement structure and what is the proper way to actually form a company and own an IV hydration business. And what Justin was saying too, in terms of corporate practice of medicine and certain regulatory issues that we face when there is a non-physician who wants to own a practice such as this. A lot of people think that an IV business, you don't need to have a physician, or it doesn't have to be physician owned, but that really isn't the case. A lot of people like, well, I go to Vegas, I go into, a spot, and, there's people there just, doing IVs. But point being, you can't rely upon that, because that is just not the proper way to do it. And so ultimately, when you go to a place like that, they'll either be cited at some point, or there will be something that happens. But just because somebody next door is doing it, or you can fly to Vegas and get an IV at the drop of a dime, it's just not, it's not legal and it's not proper. So these are some of the things that we wanted to touch upon, so that you do understand the importance of the proper formation of your business first and foremost, before you even start to get into any of these specific questions. And it is a very interdisciplinary approach, because you're talking about having regulations that you have to follow with the pharmacy boards, medical boards, nursing boards, a variety of, FDA approvals. So there's a variety of different disciplines within this mix that you really need to have counsel on, even in terms of what you're going to be mixing. There's regulations that change based upon what is being mixed. So that is what we do, and that is why we're, here to help. And as Justin said, we're in all 50 states. So I have a case where I have to go up because the DEA wants to do an investigation in Massachusetts next week that I have to go and with a client on. So these things do come up, and it is important that you have proper guidance beforehand. And, during the time that you're in business. So if you want to open up to, I don't know if you have anything else you guys want to add, or you want to have questions? So, while we're waiting, I think first and foremost is you figure out who is your staff going to be. Once you open up a practice, you have to determine who your staff is going to be. And those are the delegation rules that apply to really every circumstance. And this is considered a medical treatment. So some things will require a prescription, some may not require a prescription, but ordinarily when it is a prescription-based infusion, there has to be a physical examination that is conducted. That physical examination is going to be conducted by somebody above an RN, and the person who actually does the procedure itself can be an RN, but the rules will change dependent upon what state you're in, whether or not the RN needs to have supervision, or whether they can do it without supervision, as long as they have the prescription and the task is delegated to them. Many people, I think, forget that rule. They have a nurse that will just make the assessment, do the IV, and then chart it. Ordinarily, that is not acceptable, dependent on the state, but in most states, the RN is not permitted to do the initial good faith examination. Many times people want to do it via telemedicine. That too is possible, but also state specific, because some states require an in-person initial visit to form the physician-patient relationship, and then thereafter you can have telemedicine. Some states require that you do an audio-visual examination, whether it's FaceTime or some other mechanism, but there has to be some communication between the provider and the patient before the IV is prescribed. And I mean, I guess I just want to keep talking. I don't know what
I
you
can
guys.
chime in there real quick on telemedicine, if you want, Allyson, because that's something I encounter quite a bit in this space and others. Especially during the heavy lockdowns, a lot of telemedicine businesses popped up, and e-commerce, healthcare adjacent companies. We got a lot of questions and a lot of startups with respect to that, and the DEA, postponed some rules. That there's now some, I can speak to that in a second, sort of the unwinding of some of those and the grandfathering. But yes, with telemedicine, a general rule of thumb depends on the state. But one thing to remember is that the practice of medicine typically occurs where the patient is located, where the patient is sitting. So then it's the typical general rule, not every state, but most states, I would say, is the physician then needs to be licensed where the patient is sitting. And then further to that, when you're talking about something like a controlled substance, or when DEA approval is needed, oftentimes you're going to need to have that first encounter be face to face. And there is some grandfathering as the DEA sort of unwinds the rules that were relaxed during COVID. And one of those being, broad brush, if you established such a telemedicine relationship, you can now essentially have a buddy system where you have a DEA prescriber licensed in the state that can kind of sign off and bless your prescription, so you don't have to fire that patient necessarily. Those are devils in the details on items like this, and not everything is a controlled substance, obviously, and sometimes there's FDA approval, sometimes there's not. And maybe Jason, if you don't mind, that might be a natural pivot to you. Sorry to put you on the spot, but I wonder, what types of considerations are there for this business if something is FDA approved? What are the general guidelines? I would say things to think about, and then maybe more importantly, if something is not FDA approved, what are some things clients might be thinking about there? If you don't mind.
Physicians during a telehealth virtual telehealth visit, they can practice medicine as they please, and they can prescribe off-label, for indications of use that are not FDA approved. But generally speaking, FDA approves certain indications for certain drugs, and advertising anything on your website off-label that is not approved will have some risk. We always advise clients to have a substantiation for those claims. So, generally speaking, there'll be clinical studies on, that in particular ingredient and that indication of use. But as Justin was saying, when you're doing a telehealth visit, the physician does have to be also licensed in that particular state where the patient resides. And, going forward, it might be appropriate to have that telehealth visit for the initial consultation. But if that patient is going to continue to, be treated, generally speaking, they will have to come into the office and be examined by, a healthcare provider, the nurse or the, physician, to get, vital signs and make sure, everything is, as far as the patient safety is concerned, is, appropriate.
Well, I mean, I think that's important too, is one is, insurance. A lot of people don't actually look at their insurance policies, and it's really important that you do so, because there are times where there will be a disclaimer or exclusion from coverage if you're practicing outside the scope of what your license is, or if you're using a product that is not FDA approved, or if you're using it for something that it is not intended to treat. So it really is imperative that you either look at your insurance policy or you have an attorney look at it, so to make sure that you are properly covered, because I've looked at various policies throughout the course of my career, and I would have somebody who is a laser technician look at their policy, and lo and behold, it excludes any laser treatments. So and then God forbid there's an issue, then you don't have the coverage for it. So that's, you know, a number one. And also, it is important that you actually do have a good faith exam before you're giving any sort of treatment, because, and maybe sometimes there needs to be blood work, because there are contraindications for even vitamins that I don't think a lot of people are cognizant about or paying much attention to. But anytime that you're doing an intravenous vitamin or medication of any kind, there can be contraindications. So you really want to make sure that the person that you're treating is going to be suitable for the treatment that you're providing, and make sure that you have the proper consent forms. It's, you know, not generic one size fits all for this, because you're putting different compounds and mixes. So each consent has to be specific for the type of mixture that you are giving to the patient. We have consents that are, you know, available, that we have vetted and created for a variety of different compounds, but that is also something that you really want to make sure that you take care of. And as well as having protocols in place. You know, everybody has to have a, you know, certain set protocols, how to assess a patient, whether you have to stay with them that entire time, which you would have to monitor and make sure that the person is safe while they're having the treatment, and have a sterile environment. I mean, there's so many things that we can talk about, so you just let me.
We do have a few questions that have come in, so I can certainly start from the top. That was all, so many things. It's like a roadmap. It just keeps going and going and going. One of the first questions that came up was, does something like this webinar count towards any legal MCLE?
That's not up to me. I don't know how they have that, how it's set up, but yeah, that's a question for the IV Association.
Yeah. Okay. This one is, I'm located in Los Angeles. Are there any this doesn't maybe help for all of you, but I'm located in Los Angeles. There are many regulations are there any regulations we should be aware of? We are a new pain management clinic trying to incorporate IV hydration.
Well, yeah, I mean, there are a variety of different regulations that you have to be aware of. I mean, just in terms of who's doing the services, just the delegation, the protocols, you know, what you're compounding, do you need a hood? So that's not we could have a separate conversation, but that there are, just with any type of medical practice, and even probably a little bit more in this regard, there are absolutely regulations that you have to make sure that you're following. And, you know, OSHA is a big one as well. You have to have universal precautions. You have to have needle stick policies, bloodborne pathogens, you know, medication recalls, the safety recalls. There are so many protocols that that you need. And we do have the OSHA safety protocols, you know, available if you need that, but we can certainly have a conversation offline. But these are the things that this is what the clients that we deal with. So we'll, you know, the three of us will have somebody like yourself come in and say, hey, you know what, I'm starting a business. Can you give me, you know, the guidance of what I need? And that is precisely what we do.
Perfect. I'll make sure we share appropriate information for that individual. Another question that came up is, go ahead. Nope, go ahead.
No, I was just going to say, you know, I heard pain management clinic as well. So very likely that's going to involve controlled substances, and very likely that there is a physician involved in there. And, you know, my process and Allyson and Jason's, I think is similar. When we first, talk to a prospective client, we just get a full download of what they're hoping to achieve, what their aims and goals are, and then it's pretty basic blocking and tackling to start. It's, hey, what are you looking to do? What kind of bare minimum license do you need? What is that going to look like? What's the payer type situation going to be? What type of insurances do you need? And we just kind of work it up like that. And it is, California is one of the more heavily regulated states as well. But I would say, yes, in the med spa space is interesting because it does exist on the the edge of medicine and nursing and pharmacy and also spas as well. So there is an intersection. On the one hand, it's easier in some senses, and on the other hand, it can be more complicated because you're sort of, it touches on many different areas. So what I would say is, yes, this is the name of the the presentation as well. Is this is why it is important to speak to a competent lawyer that can help you issue spot and help you highlight what's important, what really isn't. Because I think in this space it can be easy to be lulled into a sense of security by saying, oh, it's it doesn't really matter. I know of others that are doing this, right? We hear that constantly. Other people are doing this. Why can't we? So it's very good to understand why you don't have to do something, and we actually like it when that's the outcome. So we've ruled it out. Don't need to worry about it.
Perfect. Yeah, you gotta love the comparisons. Well, if he's doing it, why can't I? And that's why you guys are here. Do you know what states are permitted at this point to allow the RN to perform the assessment with signed protocols?
I can't answer that off the cuff. I do know that in California, we've had issues where the RN has been permitted to do an initial examination with having the standard protocols in place. Ordinarily, the RN, in most states that I know of, the RN is just not permitted to do the initial assessment. That's we'd have to do it state by state, but from my research in the past, it's always been that someone above an RN has to do the initial exam, because and it makes sense because they can't do anything on their own initiative. So they're always being delegated a task to do or have to get orders in order to do it. So they're not really ever making that initial, although they make an assessment for sure, and they probably call the doctor and say, hey, this is what I want to do, and the doctor says, okay, but they just don't have the authority to do that.
Yes, and an NP may, again, state specific, agreeing with Allyson. In some states, once that script is on file, some states do allow the RNs to administer on site, and you don't necessarily need that direct supervision. But yes, it's just, I would say the best practice is to have a provider with prescriptive authority do that initial good faith exam, as Allyson is referencing, and then have it flow from there.
Okay. Next question is there any definition as to the prescriptive authority of vitamins, minerals, peptides, and amino acids?
I don't understand the question.
Individual who submitted it, if you'd like to elaborate, I will reword it, but that's what they're saying. Is there any definition as to the prescriptive authority of vitamins, minerals, peptides, and amino acids? I don't.
I mean, in terms of whether or not you need a prescription or you don't need a prescription, I'm not clear on the question, but certain vitamins you don't need a prescription for. So certain others, whether it's an amino acid or something else, whether or not you need a prescription for it, that is really sort of depends on what the pharmacy boards say. Typically, a vitamin doesn't need a prescription per se, but that doesn't mean that it is not a medical treatment and that it doesn't require an examination by someone with the authority to do that examination. So, a lot of times you'll have a medical treatment, doesn't necessarily require a prescription, but it still is a medical treatment. So I think that you have to keep that in mind. But the pharmacy boards would be the ones that direct and control whether or not it's a drug that needs a prescription or not.
Very cool. All right. I will share this comment in a later time, but one part of the comment was addressing how, it's long, so sorry. Thank you for addressing the need for provider assessment prior to nurse inserting the IV and administering the solution medication. Another aspect to possibly address is nurse competency with peripheral IV insertion and medication administration. Not all nurses are familiar with standards of practice for infusion therapy, and many learn what others have taught them, not necessarily according to standards. Just another area of liability and risk for patient harm is what this person was sharing.
Well, I mean, that is really very true. It seems almost like it's simple enough, where you're saying, okay, well, it's an IV and every nurse pretty much knows how to, push an IV, but that isn't the case. And there are protocols that have to be followed that are really very specific. And there are some states as well that will not permit a nurse to do certain IVs. So those are, things that you have to check into before you, actually hire somebody to do these services. But there are a lot of things that can go wrong. And I sort of feel that people take this really very much for granted, and that it's just sort of a very simple thing just to do, and it's not. You can have occlusion, you can have overdosing on certain vitamins. There's just a whole host of things that can happen. So fortunately, we handle malpractice cases too, but we do have a very pointed guidance for the protocol to use when you're actually doing an IV. And that goes from actually even like checking the bag, checking the lines, making sure that everything is sterile, documenting everything, getting the consent forms, monitoring the the person during the course of the treatment.
Yeah, and just to elaborate on what Allyson's saying, there are a lot of companies out there that aren't, compliant and doing things that are not, essentially safe for the patient. But anytime you're injecting someone intravenously into their veins, there's definitely protocols to follow, and you need to monitor the patient and make sure the patient doesn't have side effects, adverse effects. You need to, disclose to the patient and get what kind of medications they're on. Take their vital signs, and just to make sure the patient's safe. So there's, again, these are state-specific requirements, and it's hard to give a general blanket, guidance on some of these things.
Yes, yeah, it would echo everything Allyson and Jason are saying. And again, it sounds like a broken record. State-specific. One place to check is, seeing if the medical boards and the nursing boards and the pharmacy board as well, have position statements on this this type of thing, and many of them do, and many of the boards do talk to each other to avoid overlap. So that can be each board will have its own website, and most boards have just a tab that says position statements, and then you can click on that and do a keyword search for medical spa, IV hydration therapy, or even what a compound or vitamin is in your IV, and just sort of see, hey, best practices for IV insertion, IV monitoring, peripheral administration, the professional liability piece, that will always be state specific, and then it goes to standard of care, and so it's really going to relate to prior cases before the state boards, and also state litigation, med-mal litigation that kind of establishes that standard of care. What's the best practice, and what if something does, God forbid, go wrong with a patient, what standard of care are you going to be held to after the fact, right? So a lot of boards have issued guidance on what type of supervision is needed, what the best practices are, and then also just what the bare minimum practices are as well. And those are the things to really highlight and be aware of to make sure you're clearing the bar, so to speak. So if ever scrutinized, you can pass muster.
And very good. Another question. This may be good for later and may fit with this discussion. We are 100% cash-based service. Can you take insurance and cash from a patient, or is it one or the other? This person claims they've been approached by a company who is trying to get them to utilize their services to charge insurance on top of or as a replacement of the cash pay service.
I think it actually depends.
Go ahead, Allyson.
No, I was going to say, it may depend on the type of contract you have with the insurance company. There are definitely times where there's something that is not covered under insurance where you can accept cash, or a different form of payment other than insurance. I don't know what Justin you have to add. You're
yes,
muted.
Would definitely look at the payor contracts. So one thing to avoid, speaking generally, again, general rules of thumb, to be avoided is so-called insurance-only billing, right? So when there's no copay or co-insurance taken from the patient, and insurance requires that, right? That's something to be avoided. Cash pay and insurance, I'm trying to think if I've ever encountered that before. Of course, if insurance does not cover something and the patient wants to proceed anyway, and they want to pay out of pocket 100%, not immediately seeing a problem with that. Might need more details on that situation to see exactly what is going on. But
yeah, I mean, you're not talking about getting
a lot of
right?
a lot of procedures and go ahead, Allyson.
No, I was just saying, like, I'm not sure you're referring to getting double payment, or so if they pay cash and then you're also putting it in through insurance, or is it, I mean, I guess, yeah, a little bit more clarity. I mean, because you can't double dip, right? So it's going to be one or the other.
Yes, being paid twice is a problem. So yeah, but it would need more information to answer that more fully, I think.
Okay. Next, does OSHA or other governing authority provide requirements for mobile IV hydration setup? For example, a mobile IV hydration business in a van.
So OSHA is going to apply no matter where you are. So you could be doing it at your house, you could be doing it in a car or wherever, but the OSHA standards are still going to be applicable to any of those situations.
Okay, that would make sense. let's see here. When it comes to being a franchisor, is there a benefit to having all franchisees using the same law groups, insurance companies, HR corporations? Question mark. With every state being so different, would it be better to trying and house these important company needs under one umbrella that the franchisor vets? Do we need to understand that better?
No, I
I
mean,
would say there's, oh, go ahead, Allyson.
no, go ahead.
Yes, so this is you know, definitely efficiencies. I mean, the obvious point is conflict of interest, right? So the if it's I think we as a law firm could advise both, but it would have to be common interest, right? Sometimes the franchisor's interest can be adverse to the franchisee's interest. But what I would say is definitely efficiencies can be found if we're representing the franchisor and we're working up using our attorneys located in the various states. Like we know what your business model is, we know what you're trying to do, so we overlay that onto the specific state, and we basically flag, is there anything unique about the state? So right there's efficiency. And I do know some franchisors do provide some legal to the franchisees, if compliance issues come up. So there doesn't have to be a conflict there, but just the caveat that sometimes franchisor and franchisee interests do diverge. But I assume that's not the question. But yeah, very important and helpful to have counsel, whoever they are, they know your business plan, they know your business model, they know what you're trying to do. When I practice, I always try to be not a no because lawyer. I try to be a yes if lawyer, right? So a lot of times it's we can't get 100% of what you're trying to do, but we can probably get 95%. You just got to tweak this one area because there is this unique rule or reg in the state.
So yeah, I mean, Justin and I have worked together on a couple of different models like this, where it's not necessarily, it's not really a franchise. I think people use the word franchise incorrectly, because it's a very set definition, and in order to qualify as a franchise, you have to meet certain levels. So we have done work with people who are expanding, and they're opening up different sites, which is what I'm assuming you're referring to. And sometimes it would be you get a better discount potentially if you do have all of your I'll just say franchisees, just for want of a better word, in getting the same coverage that you have, all going through this, the same vendors, because that really would be the goal. And then, I think that you'd also then have a little bit more control, if that is what you want, so that you make sure that people are, if it's your name and your brand, you want to make sure that everybody is following the same type of services that you provide, and the caliber and level of the services you want to make sure are up to snuff. So I think, for those reasons, it is good, but what people also have to be very careful about is, in each state that you open, you may have to change the structure of your agreement with the franchisees, because Justin and I, different states will require that you have different models, whether or not there's a corporate practice of medicine or some other concern that you have to be aware of. So it's not always just as simple as just opening up different locations. They have to be
Excellent
properly
point,
structured.
We've got quite a few questions, so I'm going to keep going here. There is a person in many groups who say we have to have a hood when doing mobile IVs. Is this a fact, or would we call into the immediate use category when following a 797 don't know what that is, guidelines with less than 4 injections.
You're saying less than 4 compounds, less than 4?
They said injections, but maybe that's also, we have to be educated on that.
I would actually have to check to see whether or not you would need a hood, and I think that also, it would be state specific. So I apologize for not being able to just say yes, you definitely need it or you don't. These are detailed questions that I'd have to look it up.
Yeah, I mean, it's always best practice and advised for scale compounding to have a hood. And as far as mobile IVs, the space is still evolving. There has been certain organizations that have, put out press that they want FDA or state, health boards and entities to provide more oversight and regulations for these things. So the space is still evolving, but generally speaking, the best practice is to have a hood anytime you are, compounding sterile drugs.
Okay. This is an interesting question, I think at least. Some functional medicine practices use compounded nutraceuticals that come out of the country. Is there a specific consent or authorization the practice may obtain to cover these nutraceuticals?
So,
wow.
the thing is, nutraceutical, it's sort of like, it's not a real word. It's one of those things where, I'm trying to think of what the word that used to be. Like prescription grade, over the counter lotions or whatever. There really isn't, like such a thing, right? Because if it's a prescription grade, then it's a prescription. So there's a lot of misnomers going around. So in terms of nutraceuticals, if you're ordering it from overseas, it's not a prescription, so it's fine. You wouldn't be able to bring a prescription medication into the States and use that. So I'm just not clear what. I think I lost the question. Sorry.
Yeah, so nutraceuticals, so if it's for intravenous use, it's going to be regulated as a drug. So I'm assuming that mean supplementation through IV. So if it's anything through IV use, it's going to be regulated as a drug, and nutraceuticals isn't per se, recognized as far as FDA.
Okay, so if it's coming,
Jason, can you say that again? Because you sort of cut out on me.
Yeah, so if it's for intravenous use, because she's asking about nutraceuticals, and if, anything that's going into your drugs, whether it be a vitamin, amino acid, a peptide, it's going to be regulated as a drug. So FDA doesn't per se recognize the word nutraceutical, but I'm assuming they mean supplementation through IV use.
I think the biggest part, and that's probably very relatable. I think the bigger part of their question, though, is asking if these, in quotations, nutraceuticals that come from out of the country, should they add an additional layer of, I guess you could say, protection with a consent or authorization that they've accepted, that maybe that the patients accepted the use of these nutraceuticals that are not originated from here, that are not regulated by FDA? Should that be in an additional piece of paper or included in their consents? That's how I understood the question.
You don't need a separate piece of paper for your consent form. I mean, because a lot of the consents that we have will say, if something is being used off label, even if it's, a medication that is, properly here in the US. So you would just have a line on the consent form to say that you recognize that this is, not an FDA approved nutraceutical, and, you understand the risks of using this nutraceutical, you know, provided that you have the information about the nutraceutical and what the risks are. So just because it's coming from out of the country isn't the most important thing. It is what is included in this, and have the, you know, consent form say exactly what is in this nutraceutical. But I would have a little bit of a concern in terms of whether or not the nutraceutical that is coming from outside of the country is properly used here, because you can't take prescription medication from out of the state or out of the country and use it here. So I would want to check and to see what kind of nutraceuticals and what is it.
Yeah, and no matter where it's coming from, whether it be manufactured here or overseas, this will be regulated by FDA. You know, like I was saying before, anything for intravenous use, what you would call it, you know, a drug or a nutraceutical, it's going to be regulated by FDA. And if it's coming from a facility or, you know, offshore, that would be technically an illegal substance if it's not manufactured in an FDA registered manufacturer facility.
So then so they wouldn't be able to use it here, or they shouldn't be able to use it here.
They shouldn't, correct? Yes.
Jennifer?
Sorry. These questions are getting thrown at me, so I'm trying to scroll through some of them. We're running out of time. Sorry about that. I'm just talking to the abyss. This is related to a little bit more to the insurance question. Not double dipping, but take cash for the IV with vitamins and then take insurance for IVIG or some other medical treatment that would be covered under insurance. Same appointment, collecting cash for one thing and insurance for another.
I mean, I don't think that there's any issue with that, provided that the contract with the insurance company doesn't have any prohibition from doing that. I mean, I don't see any issue. Justin, Jason, I don't know if you have a different point of view, but
yeah, it's interesting, and you know, I'm trying to think if there's something beyond just part of it's covered, part of it isn't. You know, if that's the case, I'm not seeing the issue. I mean, what happens? I don't think this is a situation here, but when you have insurance and inducements, and you know, incentives and inducements to the patients, you know, that generate charges that are ultimately paid for by insurance, you know, that's typically what, you know, insurance companies will be upset about. But yeah, would probably need, you know, more facts on that particular situation. You know, what exactly is going on, and whether, you know, whether the, you know, it's probably not, you know, a Medicare service, but you know, look at the, you know, the billing handbooks, et cetera, seeing if there's any guidance on that question. And yeah, you know, to circle back to the question before, with the importation of something from out of country, I think there's, you know, it's great to have waivers and you know, releases and things like that, but I think at the end of the day, you know, everybody's going to have to feel good about what they're giving to patients, right? So there's going to need to be, in any event, regulations or not, you know, it's incumbent upon the provider to, you know, have done their due diligence on what exactly is in the IV, you know, quality control, effectiveness, et cetera. And I think, you know, especially in the case when something is off-label and not FDA approved, you know, I think it's going to be an even higher burden of proof, so to speak, to demonstrate that this is, quote, safe, you know, especially when, you know, that there's a bad outcome. But that's just sort of a, you know, best practice item.
Okay. I'm going to skip a couple. I'm going to go to one that's actually, they say they're in Virginia in a medical spa with a medical director, but not on premises. It's an RN-owned medical space. What are your recommendations? That's literally all they say.
Well, there's would be several. um, so if it's RN owned, and Virginia would not be the proper way of doing this. So you'd have to restructure to have like a management type of an agreement in place. And, you know, I'd have to see how is it that the people or the patients are getting assessed and who's doing that, and is the medical director, so to speak, what involvement do they have in the business, if at all? So we can have it sounds like there would be several things that have to change.
Okay. Well, there you go. Hopefully they heard your answer. This is a great question, I think, for anybody, because I hear it a lot for people that reach out to AVA, and that's one of the reasons why I think they're finding AVA. And one of the purpose for AVA is to try and centralize this plethora of information where people can slowly get started at least, and then, you know, you guys are the next step, or other entities are the next step. So in this person saying, in order to find state specifics, where is the best place to look for these resources? Because of course the legal jargon can get very confusing. So
yeah, I mean, so, you know, we started with however many states we ended up coming up with, so far 10 to 12 states that we did the IV regulations for the association. So in doing the research, the unfortunate thing is there are so many different areas that you have to check. So if you Google IV, you know, Florida, most of the things are not going to come up. So you have to check, you know, the pharmacy boards. You have to check the, you know, Nurse Practice Act, the Medical Board Act. Those are primarily the main sources that you would, and you really do have to check all of them, because you're not going to find everything in one nice little compartmentalized location, unfortunately. So, you know, you start from there, and then you'll find different statutes that will point to something else that you then have to, you know, take a look at. So, you know, I hate to keep repeating myself, and this isn't, you know, like a promo for you guys to, you know, hire us or anything. But it's for these particular reasons that, and it doesn't have to be us, it could be, you know, anybody, but you really need to get that information from counsel. You can do your preliminary research if, you know, if you want to, but these are all of the variety of different places that you actually have to look at, and then try to put it all together and in something that's like cohesive and understandable. So it takes, you know, it takes a long time, because it's ever evolving. The states don't really have all pinpointed. I mean, it's just now that many states are actually coming up with med spa regulations and some guidance on how to, who can do what type of thing. And that's still very lacking. So now this whole IV push is there are a little bit more regulations just because of the, you know, the hood situation and the mixing of the, you know, the products. But it's still evolving, and I don't suspect that we're going to see any like real good regulations for the questions that you all have anytime soon, unfortunately.
Yeah.
One point, Allyson, and you know, would say one thing that you know, I'll say normal people. You know, I'm not a normal person, because I sort of, you know,
We know that.
You know, I'm, you know, deep in a book, looking at all the regs and the laws, and, you know, no normal person would want to do that, right? So, but maybe just, you know, this is kind of an abstract comment, but I think it is true. You know, laws and regs, you know, they're typically written from the angle of things you can't do, prohibitions, right? And because it's easier to write stuff that way, as opposed to saying, this is how you do it, this is everything you're authorized to do. So a lot of the art here is, you know, with the exception of some of the states that have, you know, medical spa practice acts, and those are few and far between, it is kind of building from the ground up and knowing from experience, where you can get burned and what doesn't really matter. So you're kind of building from the ground up your business model and avoiding the prohibitions. Unfortunately, I wish there was the case that there was something out there. This is how you do it. This is the playbook, but you sort of have to build that with experience. That's where counsel really comes in. Counsel who's done it before in more than one state, and then they have attorneys licensed in that state to help sort of mold the model. But that's kind of the general point. It's that the law and the regs are written in terms of prohibitions, not things that you are blessed to do.
Yeah, and just to add, just starting with any state healthcare boards, government entities, and also FDA's as resources where you can find valuable information. But again, the space is still evolving, and everything is very state specific. But any of those government entities, have resources that definitely can be useful.
And a lot of times people think like, oh, well, the FDA isn't going to really get involved in this. They have bigger fish to fry and all that. But I'm actually finding that the governmental agencies are being much more proactive and reactive to a variety of things that are happening right now, with the semaglutides and the IVs, and even, just with regular like Botox and filler. I had the FDA actually go into a client's space very recently for filler, because somebody made a complaint that during a training the person used a filler that was from outside of the country. And the FDA came in, and I'm dealing with that now. But when I talked to the agent, I was like, "What do you mean the FDA? Like, don't you have better things to do at this point?" And they are taking all of this very, very seriously. So, it's I don't want to press any alarm buttons or anything, but the more these things keep happening and the bigger industries get, the more they're paying attention to what's actually happening. So. A word to the wise.
Okay, thank you guys so very much. I appreciate all your time. We went a little bit over, and I think this was very informative. I think the questions were great, and thank you so much for all the information you guys have provided. We have some people asking for contact information. How can we get a hold of you guys? What do we need to do? I would love to be able to help these people that have registered gain this information and expand their knowledge base, because some of the comments were definitely related to also how they're feeling that they're being proactive, but not all of their counterparts are being as proactive. And so they, good for them for wanting to take the right steps, right? So if you guys post event, want to share any information I can share with the group, with those that registered, I will do that. Or I can share those that registered with you guys, however you like to do it, let me know. And I will take some of these questions that we didn't get to, and I'll share with you. And if you have a chance to answer them and I can blast them back out, I will try to. If not, totally understand. Again, thank you all so much for joining us, and I hope you have a great rest of the day, and go IV hydration.
Thank you for having us. I hope, we answered the questions that we could. And we are more than happy to give the contact information for sure, and be more than happy to work with any of you. And we will definitely answer whatever questions that we can, offline.
Awesome.
Okay. But you're going to share the information then, the contact info? Or
I can do it on an email, or we can do it now, whatever's best for you guys.
How do you do it now?
I usually, the presenters would just share how they would like to be contacted, and if people's got their pen and paper, then they're on it. If they don't, then
okay. So
it's up to you guys.
It had to be like technologically advanced.
No. You could either say email me or reach out to my assistant to schedule. It's up to you guys. It's however works convenient for you guys.
Yeah, so email for me is easiest. So I'm at aavila@grsm.com.
Okay.
Justin,
Yes,
you
email, yep, Justin P, JUSTINP @GRSM, Gary Robert Sam Mike.com.
And I'm at JKALKIRTZ@GRSM.com.
Perfect. You guys are so nice. I'll be sure to include that in the blast as well. Well, thank you again. Very, very much so appreciate your time. I know how valuable it is. And we look forward to working together. I know one of the things that we have a big event that Ava will be present at. It's the Ivy Biz Bash that's coming up in Austin, October 13th through the 15th. It's their second year. So everyone make sure you check it out. And you guys should check out what it is. It's quite interesting as far as it would be a great opportunity for the regulatory side of the world to kind of be present, because I don't think that's enough, because it's not the fun stuff, right? It's not the glitzy glammy stuff, but it's the important stuff. So ivybizbash.com, and Ava will be there.
awesome.
Thank you guys so much. Have a great day.
Thank you. Bye. Thanks, Jason, Justin. See you.
Thank you all. Bye-bye.
Bye. How do I get out of here? Oh.